Everybody good over there? Okay.
Good morning. I'm Ward 1 Councilmember Brianne Nadeau, the Chair of the Committee on Public Works and Operations. Today is Wednesday, July 3rd, and I'm reconvening this meeting of the committee to conduct a public hearing on B25-749, the Amplified Sound Mitigation Act of 2024, and B25-639, the Licensing for Accountability of Management Properties Amendment Act of 2023, or LAMP Act. The time is 10:16 a.m. Are we good? Matt, are we live or? Okay. Okay. The placeholder screen is still up on cable. You see me? Okay. Great. I'm glad everyone can see me and hear me. All right. So today we'll hear from our government witnesses. We are joined by April R. Randall, Legislative Director at the Department of Licensing and Consumer Protection, Kelly O'Mara, Executive Director of Strategic Change Division at the Metropolitan Police Department, and Keith Parsons, Strategic Enforcement Administrator at the Department of Buildings. Before providing testimony, I'm going to administer an oath to you all. So if you could please raise your right hand, and Keith, unmute yourself. Do you swear or affirm under penalty of perjury that the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do.
Great. Have you already decided the order you're giving your testimony? Okay. Fantastic. Thank you so much.
Good morning, Chairperson Nadeau, committee members, and staff. I am April Randall, the Legislative Director with the Department for Licensing and Consumer Protection. I'm here to testify on Bill 25-749, the Amplified Sound Mitigation Act of 2024. I am joined by my colleagues, Kelly O'Mara, Executive Director of the Metropolitan Police Department's Strategic Change Division, and Keith Parsons, the Department of Buildings Strategic Enforcement Administrator. At the outset, DLCP believes everyone should be able to live, work, and play in the District of Columbia free of nuisances, including excessive noise levels. Excessive noise can adversely affect one's ability to enjoy their home, work, and play in the district. Understandably, however, in a vibrant, bustling metropolis such as the district, noise is expected. Balancing the tension between living comfortably and working comfortably in one's home free of excessive noise and a vibrant city is challenging. Bill 25-749 will amend sections 2800 and 2900 of Title 20 of the District of Columbia Municipal Regulations to regulate amplified noise in the public space by establishing maximum decibel levels as well as a civil infraction for those violations. Further, the bill would name DLCP as the agency responsible for enforcing the laws outside of its operating hours or additional enforcement resources are requested. While we respect the council's attempt to address excessive noise in the district, an issue the city has wrestled with for over 10 years, the bill's enforcement structure is complicated and will not work. It is for those reasons we oppose this bill. First, the bill will require DLCP to issue a verbal warning to a person who exceeds the maximum decibel levels. This is done to provide the individual with a reasonable time to address the violation. In practice, what will actually happen is that the person will reduce those noise levels within the legal limits, and once the investigator leaves, they'll turn the volume back up. This is particularly problemsome as it relates to amplified noise coming from cars, which the bill also includes. The driver or the other occupant of the car will turn the volume down, or they may just simply leave. In either event, the excessive noise will not be addressed. If, after a warning is issued, the violation persists, the bill allows the investigator to issue a notice of civil infraction. For this to be effective, the investigator will need to return to the scene and observe the violation, including measuring that noise level. This live observation and reading is the only way there will be grounds to substantiate the violation, thereby justifying the civil infraction. However, chasing after violators is likely not the best use of DLCP's resources, given we are also required to investigate other pressing matters of public safety. Further, in our experience, notices of infraction are an ineffective a means of changing behaviors, particularly when the individual is unlicensed. When there is a risk that one's business or occupational license may be suspended or revoked, enforcement action is more effective. Yet, Bill 25-749 is not tied to a business or occupational license. Thus, the notice of infraction will not likely have the intended effect of curbing the behavior. Furthermore, DLCP can only issue a notice of infraction if it has the individual's name and mailing address. Like the Street Vendor Enforcement Act, Bill 25-749 does not require one to possess reasonable identification, which is also not defined. Instead, the bill will require the individual to provide their name and legal address to the enforcement officer. Only if, after the enforcement officer believes the individual is not being truthful, will they be able to request reasonable identification. If the individual refuses, the enforcement officer may detain the individual, but detainment is not the same as arrest, nor does DLCP have arresting authority, and this bill would not give us that. Thus, if there's nothing to prevent the individual from leaving the scene, which in turn further reduces the effectiveness of the legislation. We have found some challenges with this framework when attempting to conduct effective vending enforcement, and believe we will face those same challenges with this bill. Any legislation passed should be enforceable and operationally practical. Enforcing noise from motor vehicles is also particularly problematic. Would the bill require DLCP to monitor noise emanating from vehicles that are in motion along the city streets, stopped and/or parked, or both? In either scenario, it is problematic, particularly if the car is driving along the city streets. DLCP doesn't have the authority to pull someone over, and this bill would not give us the authority to do so. Thus, it is likely that the agency would not be able to take any action in these instances. Noise complaints from motor vehicles can best be addressed under Title 50 of the DC Official Code, where the violation is tied to the operator's license. Additionally, the bill would not require DLCP to enforce noise outside of its hours of operation, which are from 8:30 to 4:30 p.m. Monday through Friday. Investigators' tour of duty is from 8:15 to 4:45. As drafted, the bill would not require DLCP to enforce excessive noise after those hours. Yet it's unreasonable to expect district residents to readily know that DLCP is no longer responsible to enforce noise after those hours. Who would be responsible for enforcing noise after DLCP's hours of operation and until 10 p.m. when MPD can enforce noise under the noise at night law? This gap in enforcement will be detrimental to the effectiveness of the bill. Should the council move forward, however, with approving Bill 2549, the enforcement responsibility should not rest with DLCP, whose mission is to protect the economic interests of businesses, residents, and visitors of the district by licensing and regulating businesses and investigating and enforcing the Consumer Protection Procedure Act. The agency's mission can be summarized as regulating business activities in the district. This bill would expand the agency's mission to include enforcing activities that are not associated with business activities or operations. Further, DLCP would require additional resources, including additional staff, the need to purchase equipment for measuring sound levels, and to train staff on the use of such equipment and to investigate noise complaints. DLCP's investigators do not have the expertise to measure noise levels, and the agency does not have engineers or professionals on staff that are experts in measuring these levels and the standards of determining decibel levels. DLCP staff is not familiar with the standards established by the International Electrotechnical Commission, IEC, or the American National Standards Institute, ANSI, as stated in the bill. Should DLCP take on the responsibility, it would need to hire experts in sound engineering and noise level measurements. In addition to hiring additional experts, DLCP would need to hire additional investigators. We are presently hiring additional investigators to fulfill our other responsibilities, particularly as it relates to vending enforcement. To take on this responsibility will require the agency to establish a new enforcement team dedicated to this task, thereby necessitating the need to hire additional investigators, program managers, and possibly an attorney as well to handle the increased NOI appeals that we are likely to see. In addition to hiring new staff, we will need to obtain measuring devices, which we do not have, and additional fleet vehicles. It should be noted that Bill 25-0749 provides the enforcement responsibility primarily rests with DLCP unless the agency is outside of its operating hours or additional enforcement requests are needed. As I have already previously explained what our hours are from 8:30 to 4:30, and investigators or tour duty is from 8:15 to 4:45 p.m. In addition to the staff and experts, we will also need additional fleet vehicles, measuring devices for measuring sound, if we were to take on this responsibility. This provision raises additional concerns regarding the implementation of this bill and thus the likely effectiveness of meeting its purpose. Again, we recognize that noise enforcement is complicated and cannot be easily addressed. And we do applaud the council for these attempts, but more conversations are necessary in order to determine what the best course of action should be. I would like to thank the committee for allowing me to testify today, and I'm happy to answer any questions you may have.
We're going to do 10-minute rounds of questions. We've been joined by Chairman Mendelson, who's the author of the legislation, and I'm going to let him go first for his 10-minute round.
Thank you, Chairwoman Nadeau. Good morning.
Morning.
So, Ms. Randall, you're the legislative
Director, legislative director. Yes.
I have to say, I'm kind of appalled at your statement. So you appreciate that sound is an issue in the district and that sound is important, or noise can be an issue to quality of life for people in the district, and therefore that the district ought to address this situation. Correct?
Yes, we recognize
Okay.
this issue.
You offer no suggestions in your testimony. Correct?
Well, as it relates to how the DLCP can enforce it, we have concerns with our ability to enforce it and do not believe that the agency.
No, what's the suggestion for how the district deal with noise?
Yes, we would like to discuss that further with the council. There are several agencies, two of whom are joining with me today.
Well, that's
regarding
what the
enforcement.
hearing is about but there was an opportunity before the hearing to make suggestions or offer a meeting.
And we will be open to that. Would like to have those further discussions and have the other.
Why do
necessary-
you come in now and not earlier on this? This issue is not new.
No, and then we also recognize that this is of importance for the council. And so we do
And-
acknowledge that.
How do I experience that you actually think this is important?
Well, we have not initially been involved in these conversations regarding the bill. We recognize that. This is something that is of importance to the executive.
So
And-
what suggestions do you have?
We would like to be able to discuss those a little bit further, Councilmember.
We'll discuss what?
How we can work with it.
I'm
I
looking
know.
for substance here.
Well, we will have to determine, well, one, regarding, it is multifaceted, it's very complicated. I definitely recognize that. And
Okay.
so to be able to think of something off the cuff would be difficult. I think that's some of the challenges that we have had of late is trying to figure out the best course, which way to go, which agency, and it would be more advantageous if we actually have more like maybe a working group around
Okay, and the
conversation around it.
DLCP suggest that? The council's had 2 hearings on this legislation before today.
Well,
you know that?
that was with DCRA, and I was not there, but my
Okay,
colleague who
but
was
you are
involved.
representing the government.
Yes,
You are representing the executive.
yes.
I think the mayor was the mayor in the past. So there've been a couple of hearings. This legislation was introduced a couple months ago, but is in many ways very similar to legislation previously introduced.
There,
And so this is the first I'm hearing this offer to have a meeting, be that as it may, to discuss to discuss how to address noise, but you offer no suggestions in your statement. DLCP is coming to this hearing
Mhm.
with 0 suggestions, correct?
Well, the suggestion is to have greater discussions around it, but my colleague,
So-
Kelly O'Mara has, oh, sorry,
Well, I mean, what's the hearing but an opportunity to discuss this?
that is true.
So you're coming to the discussion with nothing to discuss.
Well, my colleagues that are also here have other suggestions as well.
Okay, I don't think Miss O'Meara, whom I know and like, and is very good, she's not the one with a written statement testifying on behalf of the executive, am I correct?
But she's here to assist with answering
So
questions.
is it the position of the executive that people should be arrested for making noise?
We would not recommend making.
Okay, is it your, is
criminal.
it the position of the executive that people in the district need to carry identification at all times?
We recognize the challenges with that, but we also know that it's difficult
Well,
to
it
be
was
able
sort
to
of a yes
determine.
or a no. Should we change the law and require people carry identification?
Not necessarily.
Okay, so then if we're not requiring identification, that kind of undercuts your criticism that people won't have identification. Is it your position that people should be licensed if they're going to busk?
No, we would not recommend licensure.
Okay, so you criticized the bill because people don't have identification. You criticized the bill because people don't have licenses. And you criticized the bill because you don't have the enforcement ability to arrest somebody, but you don't want licenses, you don't want to arrest. I'm kind of at a loss here.
Chairman, may I?
Yes.
Thank you very much. Good morning. I think, we've been obviously talking about this since before COVID, working on this issue. And I think there's a couple of different ways to approach it. One of the things that I think can be effective is not grouping together unlike situations. So we're grouping together in the legislation, noise from cars, noise from things that are going to have First Amendment protections, and potentially noise from businesses. So 2 of those buckets are activity that is sort of otherwise regulated. So the challenge in terms of people not having identification. One of the reasons why, we had been discussing internally the suggestion that dealing with the amplification, amplified noise from cars, that we deal with that separately, is to create an enforcement mechanism, much like when you and I were working on littering together, where we had littering violations for just pedestrians, and then we had littering violations for littering from a vehicle. Because there's already an enforcement mechanism. People are licensed and are required to give identification. And so that's a very discrete subset. If we're talking about businesses that are brick and mortar businesses, they obviously have ties to the government. They have licenses, they have certificates of occupancy. That can be another group to look at in terms of how that is regulated and enforced. And then there is still a very challenging bucket of things that have First Amendment protections. And so we've had some discussions on that. It continues to be an issue. MPD isn't going to say, we think the noise level should be here. That's really a discussion, a policy discussion. What we can say is we can or cannot enforce under that mechanism. Or, in our experience, we can highlight things that, for instance, the court has been involved in cases that we've been involved in. So we are very happy to talk about that. But I think looking at those discrete buckets may be one way to approach the challenges that our communities are legitimately dealing with. We recognize that it can be very difficult to live with extreme noise coming in.
I appreciate what you're suggesting, and there might be something there, but I've got to tell you, having been involved with this issue, I have never thought this was an issue about automobiles. So an automobile, the only way that an automobile makes too much noise is if it's got something like a bad muffler or an intentionally loud muffler, or they've got the radio cranked up. Usually they're driving.
Mhm.
And so as obnoxious as that is, they're not going to be there for very long.
Indeed.
I'm thinking of
Indeed.
7th Street and you may, meaning MPD may already have ways of dealing with that. I don't know, but that wasn't what we were thinking of here. We were thinking of buskers.
Mhm.
That was the testimony yesterday, and aware of First Amendment demonstrations. So the bill says electronically amplified sound. So
Mhm.
most demonstrations don't have electronically amplified sound unless it may
Correct.
be a megaphone.
Correct. I mean, certainly there are some that do. We're dealing with some now. I would, to get back to the vehicle, I mean, the legislation does specifically mention vehicles and amplification. So I was thinking we were talking about music or other sound from vehicles. I know the chief was just at a community meeting 2 weeks ago where someone who lives at the intersection of 15th and U Northwest was talking about how the noise from vehicles disturbs them. I agree. We have to look at, is that worthwhile? Because they do just drive through.
Well, we
But I-
could, so the testimony could be that we should strike, including from vehicles. That's an easier suggestion than what Ms. Randall suggested, which was actually no suggestion. It was just, well, we don't require a license and you can't arrest. And you stop working at 4:15, and it's like, how many different ways can we find? Oh, and I left out that we'll have to buy sound measuring equipment, and have to buy vehicles, and we'll have to buy inspectors. And I kind of remember that from a few years ago when
Mhm.
there was a bill regarding DCRA, and it was going to cost, I think, $80 million. No, that's wrong. It was to hire 80 people. I think there can, so that would be a constructive suggestion to say, all right, we'll strike motor vehicles from it, but I don't think MPD wants to be arresting people.
We don't. We don't. I mean, we've said continually, this is an area where, and we see this in other issues, where we have community sensibilities and individual rights and trying to find where the balance is with those is going to always be a tension. But that's why we're talking about looking at those areas where it is regulated, not again suggesting buskers be regulated, but looking at areas where it is regulated already and how we can do enforcement there. You know, ABC establishments is an area where a lot of progress was made because we looked at that problem specifically and how we could work together with
Yes,
then
but
with
our
ABCO.
challenge is the buskers.
Yes, sir.
That's really our challenge.
Okay.
I don't recall any testimony in the past or yesterday involving ABC establishments or automobiles or brick and mortar. It's the buskers. And so you said to deal with that tension, to find the right balance, to deal with that tension. I think that's the way you put it. So what the bill says is 95 decibels measured at the source. So what can we do in legislation that gives either a police officer or a DLCP inspector the ability to go up and say, hey, you're 90, you need to turn it down. So we said 95 to turn it down,
Mhm.
not to be arresting, not to be doing all these other things. That's the goal. I'm looking at you, but I really should be looking at Ms.
No,
Randall.
I'm here as well to talk about it. I think from MPD's perspective, we would be best able to deal with enforcement issues if it was a reasonable person standard. And I think that's something we talked about, you know, again, 5 years ago, and how we might address that so that we don't need to be either trying to coordinate, because these are paths we've gone down, trying to coordinate with multiple agencies so that we all arrive at the same place at the same time while the violation is going on. Or we don't need to have a unit of noise enforcers at MPD, particularly, you know, with our staffing down, you know, 600 people from where we were the last time we were meeting about this.
Yes, but reasonable person standard is totally subjective.
Well, yes.
And I don't
yes,
know
and-
that it matters if the person turns it down, but if they refuse to turn it down,
Mhm.
I don't know how you enforce a reasonable person standard.
So if we look at, for instance, noise at night, it's not not necessarily just a single point.
Yeah, but
where we
noise,
do it.
noise at night is disturbing the peace, right?
Mhm.
Okay, that has a whole criminal statute around it.
Right, but it's, as an example, it is, so we have that authority. We know noise at night is still an issue. There was testimony offered yesterday saying that, we're responsive and able to address it. We're doing that without a lot of arrests because the authority is built in. So over 2020 to 2023, we had 9 arrests total. And 4 of those, there were other charges included. 5 of those was a non-custodial arrest, a 61D. And so that's an example where we do have discretion and we're using it well.
Well, is the mayor asking that because arrest means it's a crime. Is the mayor's position that we should make this a crime?
No, sir.
Well-
I'm giving you examples and having this discussion. The First Amendment area, as you know, we've been here before. It is going to be a very careful balance. I've been looking at this issue for a decade, and I don't know that it's been addressed well anywhere else either.
Yes.
And we
well,
have the unique situation where we have probably more First Amendment assemblies than any other
yes, well,
jurisdiction.
but this bill seeks to address all that.
Mhm.
And all I have as the position of the executive is Ms. Randall's statement, which criticizes the bill in every aspect. Like, you can't arrest, but you don't want to arrest. Well, no, that's not acceptable. We need a solution here. So the way the bill's written is that there's the ability of somebody who's not MPD to go to somebody and say, hey, you got to turn it down. I'm way over my time. And maybe the chairwoman will be nice enough to give me a second round.
I'll ask a few questions, see if that sparks any other things that you would want to talk about, Chairman. Thank you both. I want to just back up and start with some basics. We've talked previously about DLCP's current authority related to sound complaint enforcement, but can you please describe it again for the record?
Well, DLCP, and thank you for the question, does not regulate sounds. So what we do enforce is as it relates to trash trucks operating outside of permissible hours and gas-powered leaf blowers, which are precluded in the district. So when we receive those complaints about a trash truck operating outside of its permissible hours or the use of a gas-powered leaf blower, our investigators respond to the complaint to see if the actual operation or usage is taking place. But there's no measurement of sound. It's not it could be the truck could be off and not making any noise. Or you could have a gas-powered leaf blower that doesn't make as much noise, but that's not what the regs provide. Is trash truck cannot operate out of permissible hours, cannot use gas-powered leaf blowers. So those are the complaints that we're responding to, the usage.
How did it come to be that you have authority over trash truck noise and only trash truck noise, not any other type of truck and only that type of vehicle?
Well, that's in the regulations
Yeah.
that the council drafted. We passed law.
Uh-huh.
So
Was that became the case once the agencies were split up?
those 2 responsibilities did transfer with DL.
And Mr. Parsons, what did DOB retain in terms of authority over noise violation?
Good morning, Councilmember, and thank you for the question. So the Department of Buildings has a division that reports to me, the property maintenance, section, and they do the noise enforcement that remains with the Department of Buildings. So if we get a complaint about noise, it comes in through the normal process where anyone would complain about a housing or property maintenance violation. It gets scheduled within our 15 business day SLA. We do have the noise measuring devices, and a member of the team will go out, and if the noise is still occurring, they will take a measurement under the current regulations and attempt to bring the violator into compliance. The areas where we have been effective on this are generally with fixed source noises, meaning things that are attached to buildings that are closer to our mandates, things like chillers, air conditioners, other mechanical elements. We are able to potentially cite the property owner, and of course we have the expertise within the department to issue correction orders and such if that device isn't operating properly. For anything else, in particular anything that is a mobile source, we are not well situated to respond to it for some of the similar reasons that the LCP has testified to. Obviously, within our normal response times, the source may not be there. And there's difficulty identifying any sort of mobile source to issue a civil infraction. So that is DOB's noise enforcement currently. I guess I will also add that in the case of construction noise, the illegal construction team has the option to cite that. It is not usually used unless it is operating outside of construction hours issue, because most construction devices are allowed to operate at whatever sound level that they make, as long as they're running properly within normal hours.
Okay, so what kind of noise complaints do you currently receive from the public? What are the nature of them?
Apologies, I muted myself briefly because some construction noise above me on the floor was really loud in my office. I hope no one could hear that. If so, I apologize. I mean, anyone can complain about anything. So primarily, we receive complaints about, like I said, fixtures in buildings, chillers, pipes, things of that nature. In recent history, we have also received a complaint about an exercise class that was occurring outside, but it was still something where, emanated from a fixed address. It was still very difficult to measure, because if the class wasn't in session, the source would show up and it would be in compliance.
Okay. Who are we missing here? ABCA? Like, whose job should this be? If it's not MPD's job, it's not DLCP's job, and it's not DOB's job, because we're trying to solve a problem. We got a lot of you here. Doesn't seem like we're getting anywhere. Anyone have any advice on who should be doing this?
I mean, I think when we're talking about the buskers and the First Amendment assemblies or other First Amendment protected activity, we are going to run into this challenge. And we haven't come up with, in the many years we've been working on it, a good solution in terms of the challenges of trying to issue any civil citations for unregulated activity. We're talking about something that requires a measure of voluntary compliance if somebody is unregulated and they receive a civil citation. And we know right now, particularly since COVID, levels of voluntary compliance in enforcement mechanisms without any teeth are, we'll just say, very low. There isn't anybody set up right now to do that enforcement in a civil manner, as I understand is, what the direction is. And so it's going to take a measure of creativity.
So I think one of the reasons that we look to DLCP on this, thank you for that answer, has been, when it comes to busking especially, this is regulating business activity, right? Maybe it feels like a bit of a stretch, but to solve this, we are going to have to stretch. How does why is it such a leap from, say, leaf blowers and trash trucks and other business activity to regulating amplified sound for DLCP?
Well, those are not necessarily business activity. And here you would not, there's case law that's also that says that First Amendment activity, we cannot license buskers. So you're still going to run into these same challenges. And I think that in part is particularly where that tension lies. So whether we license them, which the law, of course, would challenge, and issuing NOIs or arresting them still raises those same First Amendment concerns. So it's really difficult to even contemplate what will be the best structure. But yes, it's going to require some creativity that will require greater discussion and exploration. But it is, we do see that to be different than operating the trash trucks outside of permissible hours and just using the gas-powered leaf blowers, which are strictly prohibited.
What's the current process for responding to sound complaints? And before you answer that, the current hours for enforcement staff is 8:15 to 4:45, you said?
Yeah.
Trash
That's
truck
true.
noise is starting at what time usually?
I think it's 7, but I don't know. I
Yeah,
haven't looked.
they're not allowed to go out before 7. So there's already, I'm looking at a gap of an hour and 15 minutes where you don't have anybody. So when someone calls in, let's say I call in at 7 a.m., the trash truck is making noise, what does DLCP do? Take a message, something like that?
Well, we will have to explore that. I have to talk to enforcement staff.
Yeah, I mean, presumably that becomes a voicemail or a 311 referral or a ticket, but then the trash truck's gone. So it would be helpful to know how many citations we're actually giving for trash truck noise in the first place.
Well, and these are approximations. For the trash trucks in 2023, there are approximately 73, give or
Mhm.
take. And to date for FY '24, approximately 60.
So what resources do you currently have for sound level enforcement?
None.
So how do you issue the citations?
Well, again, those are staff, our investigators. We have the investigators to handle these complaints, but in terms of measuring, if that was your question, or determining decimal levels, because that is not something that we currently do and are required to do, we don't have those resources, but we have staffing to address these current responsibilities.
Is ABCA the only agency in the government that has sound measuring tools?
I don't believe they do have sound measuring tools.
Nobody has sound measuring tools.
I think DOB does.
Mr. Parsons, does DOB have sound measuring technology?
That's correct, Councilmember. We do have the sound measuring devices.
And what hours are your people investigating sound complaints, noise complaints?
Normal business hours, which I believe is basically 8:30 to 4:30.
Why are those the hours?
Those are the normal operating hours of the agency. We have occasionally, when there's a component of the complaint about when the device operates, we have occasionally tried to go out when the complainant represents that it is operating at its highest level.
Ms. Randall, why are the current enforcement hours 8:15 to 4:45 at DLCP?
For the same reasons, to allow the investigators to onboard before the office opens and to get situated. And if they have to close out any reports that they have to do past the 8:30, so I mean, past the 4:30, excuse me, to 4:45.
Do either of your offices have people in the agency that work a different shift than that? For any reason,
There have been times where we're paying them overtime,
like the nightlife task force?
similarly, yes, in part. But that's not a regular team.
What about DOB? DOB is part of the nightlife task force, right?
So the Department of Buildings has the duty officer, which is a sort of group of very high-level managers and inspectors that responds to things like fires and other issues that affect the structural integrity of a building on an emergent basis at night. The duty officer does not respond to noise complaints because they're not emergencies, and of
Mhm.
course, the response to the fires and real emergencies takes priority.
Okay, I'm gonna ask one more of each of you and then I'll kick it back to you if you have another round, Chairman, but just to clarify, how many regulation standard decibel readers do each of your agencies have on hand?
The LCP does not have any.
Neither does MPD. That's not part of our responsibility.
DOB?
I do not know the number, but I can get back to the council on that, Councilmember.
Okay, thank you. Chairman, would you like a round?
Thank you, Chairwoman Nadeau. Who, Ms. Randall, what agency? Is it your agency that has responsibility for Title 20, Section 2800 of the DCMR?
Regarding trash trucks and the gas powered leaf blowers, but not the entire chapter.
Well, who does?
There's a mixture of different agencies involved in that. MPD, DOB may be involved as well, but it's not just one.
So you
agency.
don't know?
I'm not as in tuned of all the
Okay,
different.
you're here
agencies.
testifying on behalf of the mayor. So I would hope that you would have the answer. So right now, there is in the regulations requirements with regard to sound in residential communities. Who has responsibility for enforcing that?
It's not DLCP, it may be DOB. I mean, since the split, I understand it was DCRA, but that was not a responsibility that then shifted to DLCP.
Mr. Parsons, is that your responsibility?
Apologies, Chairman. Can you repeat the question? What was the
Yes, I'm
specific
asking
question?
about the noise regulations in affecting residential communities that's in Title 20, Section 2800 of the DC Municipal Regulations. Ms. Randall thinks that that's a Department of Buildings responsibility.
So my understanding is that our responsibility is, as I described earlier, right, where we will respond to complaints.
Regarding fixed structures like HVAC units, coolers on top of buildings, things like that. So then
That's
my
correct, Chairman.
takeaway here, I'm going to look at Ms. Randall, is even though you are here testifying on behalf of the executive, based on the testimony I'm getting, it is the executive's position that there is nobody responsible for enforcing the current regulations.
We could take a further review, but since the split, that was not a responsibility that was shifted, that DLCP has taken on.
Well, it's not a Department of Building responsibility. It's not an MPD responsibility. It's not a DLCP responsibility. So what the mayor is saying to us at this hearing is that there is no agency responsible for enforcing the existing sound regulations. I'll assume by your silence that that's correct. And it's also my takeaway from this hearing that the executive is opposed to this bill, correct?
is currently drafted regarding the structure of enforcement and the placement of responsibility.
But it's also my takeaway that the executive has no suggestions for how to redraft this, correct?
Well, we are willing to work with the council, the committee. both
Do you
ways.
have suggestions? We went over this earlier. I didn't get any. Do you have suggestions?
Not at this time.
Okay, so I can go back to, for instance, Mr. Marks and his community who testified yesterday and say, the executive has abdicated any responsibility for enforcing the current sound regulations. The executive opposes this legislation, which he, by the way, supported, and that the executive has no suggestions for how to either improve the bill or to enforce sound regulations in the district. That's my takeaway, because I'm not hearing anything else.
Well, it would be that I would suggest, and I hear you, I do understand your frustration. Because this is a frustrating issue trying to address this. So I do respect that, Chairman. But what I would say is that we recognize that, I heard the testimony as well, including Mr. Marx's, that there is a grave concern regarding amplified noise that is disturbing residents and businesses, et cetera. That the executive recognizes and appreciates that. We want to work with communities. We want to work with the council to see what we can do, how we can be creative in addressing these matters. You recognize some of that tension as relates to the split and determining responsibilities that does present a gap. So I would say that we want to work with our communities and work the council to figure out what we can do and how we can craft legislation to address the issue.
Well, I didn't want to interrupt, but this issue is not new, you agree?
It isn't, no. it
And
is
you're
not
coming
an
to the
issue
table with no suggestions?
Because, I'm sorry.
I don't have any suggestions. I don't have a copy of your statement, but I recall that what you said was, well, you can't enforce it because of automobiles, and you can't enforce it because you don't have sound measuring equipment, and you can't enforce it because nobody has a license, so you can't yank the license, and you can't enforce it because you can't insist on an identification, and you can't enforce it because you can't arrest people, and you don't want to arrest, and you don't want a license. That's maybe constitutionally a problem. So this is really not a good message to say to the residential community in Chinatown, or the residential community at West End, or the residential community in Columbia Heights. But you can be sure that this is what I'm going to say, is that we put forward our best effort, and the executive made it clear that it didn't support any of it, didn't have any suggestions. And if we were to pass this, you made it clear that you will tell the chief financial officer that there's a huge financial impact, so of course it won't be enforceable. I see nothing but obstacles that you're raising. Is that unfair?
We recognize, we pointed out the challenges as drafted. We recognize that they are challenges. And what I posit is that we will want to work with the council, our sister agencies that are also involved in enforcement of noise, that have some role, and community members that have a vested interest to figure out what can be done.
So when we have this meeting, you're going to come with suggestions?
We will have some suggestions to posit input for us.
Well, so then how about if I suggest this, that by August 1st, that's roughly a month, that you give us, that means give the Committee on Public Works and Operations some legislative language.
We can try our best efforts.
Yes, Ms. O'Meara.
Thank you, Chairman. Yeah, I think that is a very short time to deal with the constitutional issues that we've been talking about for quite some time. You know, the administration, MPD recognizes frustration because we're out in the community every day. We hear the complaints. Our officers do the best job that they can do without necessarily having the authority to, take enforcement action. We work to mediate complaints as much as we can. But the First Amendment issues here are real. The challenges of trying to enforce something when people are not required to carry ID, they're real. This is not a simple issue. Some of these issues we talked about in 2018. Some of the challenges with the Noise Control Act, we've talked about before. And a month is simply not what's needed.
Well, how much time? And before you answer that, so these issues aren't going to be any easier in 2 months or 3 months or
No,
4
sir.
months. The purpose of the hearing is for the executive to come forward
Mhm.
with comments. Yeah, I'm saying that it's unacceptable to come forward and trash everything and offer no alternatives. So you've had since March, when this bill was introduced, to think about this. So point one is the constitutional issues get no easier in 2 months or 3 months or 4 months
Mhm.
or 1 month. And second, that you've already had several months. And then as you point out, actually, we've been dealing with this. I think I've had conversations with you, Ms. O'Meara,
Mhm.
in the last several years. So you've actually had several years to look at the constitutional issues. The fact of the matter is that it's not a constitutional issue to say that an enforcement officer would ask for identification, and if there isn't identification, then to ask for the person to identify themselves, because we already have that requirement. We have that requirement, I think, in the law regarding fair jumping,
Mhm.
which got legislated several years ago. So the point being, there's already been many months to look at the constitutional issues, and I don't think there's a constitutional issue around the bill as drafted.
So if we can talk a bit about the identification issue. You and I came up with a scheme that is now in the fair evasion with the littering. And what we know is that, we can ask people for their identification, or rather to give us their name and address. Even if they give us the real name and address, there's nothing compelling them to actually comply with that violation, because the district government can't hold them accountable for it if they haven't provided government issued ID. So neither the OCFO nor the OAG can pursue, or rather OAH can pursue any non-compliance with the tickets if there's no identification.
I'm not so sure about that, but the goal here is to turn down the music, not to be ticketing people. And the goal here is to turn down the music, not to be
Mhm.
collecting money from people. The goal here is to be turning down the music. So frankly, I think without this bill, MPD officers could go up to very loud buskers on 7th Street and say, hey, turn it down.
And we
Your
do
folks
that.
choose, I was going to say choose not to do that. You're saying you do it. I don't know. I've been out there. It's been a couple of years before the pandemic when Darth Vader was playing an electric guitar so loud. It was pretty amazing. Then there was nobody going up to him and saying, turn it down. That's the goal, is to just get them to turn it down. And right now, what I have heard is that everyone in the government feels that they don't have the authority to go up to somebody and ask them to turn it down. So that's what this bill is about, which is getting away from the point that I don't know what more would be accomplished with 2 months than can happen in 1 month, given
Mhm.
how much time has already been put into this. And the fact that we have a pretty good idea of what the constitutional issues are. And so I'm asking Ms. Randall to give some legislative language to the committee. Take a month to do it.
Or that is true. I think
Then we'd have something to talk about.
as my colleague mentioned, 1 month would be challenging. It would not be the best. We want to be able to actually have something that's workable. And this is still a little bit more than just telling them to turn it down, right? That would be the initial response, that the verbal warning. But that was one of the challenges that I mentioned. The investigators will leave, they'll get loud again. They
I
have to
think
go-
we're
and
back to,
I know, we
with
are,
all due
we are.
respect, I think we're back to the obstructionism.
Yeah,
So I can tell you the community, if you want, I can say to the community that the executive doesn't have suggestions.
Well, we're moving forward with this bill one way or another, so I would like to be able to do it together. I think, ideally.
I agree.
Sorry to interrupt.
I agree. And what I'm also hearing from you, Ms. Randall, is pursuing the perfect, and there's not going to be a perfect here. Am I making sense?
I understand, but even something that gives residents a true sense that something will happen is also worthwhile. And that is where the tension lies. And so that's what we would more likely want to recommend to council that we do, as opposed to try to respond with a knee-jerk just amendments to what's here, but actually work with the committee and the council as a whole, work with you to try to craft something that is workable, because even with the NOIs, they will still present First Amendment challenges.
Mhm.
And I think that is a very real concern, even whether we arrest them or not, the NOIs issuing it will still present the challenges.
I'll leave it at that. Thank you.
Before, are you leaving? Because I wanted to know if Darth Vader was any good at guitar.
It was horrible
Okay, well.
and very loud.
Okay, well, before you go, I think that, I think we should make a commitment today that the committee will work together with DLCP immediately so that August 1st, we have something that we can show for that work. I think that's reasonable, given how much work your staff and my staff have already done on this issue. And let me just share some additional ideas, since we're trying to be productive. San Francisco's noise enforcement is led by the Department of Public Health, just FYI. San Jose prohibits the use of amplifiers entirely unless you have a permit from the chief of police. Seattle seems to also include animal control officers in their agency that enforces the noise ordinance. So maybe that's also a health intersection. Alexandria has a blanket prohibition of amps in all parks, and Houston requires a permit for any amp usage. So let's think through how we could perhaps focus on the equipment, focus on what people are required to do in order to set up equipment. The amplification has always been a key piece of this issue, right? Somebody who is standing outside shouting without a microphone is much less of a nuisance than someone who's got one. And musicians can perform without amplification as well. So maybe let's focus in on the amps themselves. Maybe we're getting too fancy trying to focus on the exact reading, but let's open up the conversation. I know the chairman has worked on this a lot longer than I have, so I defer to him on the history of all of the things that have been explored. However, I've been at many of those hearings, so I've heard the discussion all this time. I think let's find a way to solve this issue for the community that actually gets at the root of the issue and is enforceable. I wanted to ask, so for DLCP, Chairman got at the issue of ID. You noted this may be a barrier for enforcement in this situation too. The rules are similar to those outlined in the Street Vendor Advancement Act, which you've also indicated there have been challenges with implementing. Can you describe those challenges in more detail, since we're just beginning to implement that law?
They're the same, yes. As relates to them actually, individuals actually providing their actual real name and address. If refusing to do so, we cannot arrest them. And again, I'm not arguing that we should do so,
Mhm.
but detaining them, asking them to stay in their place for a reasonable time to provide, has not been fruitful. They will still leave, and we cannot go and chase them because we can't arrest them. If they do provide a name, even if the investigator would think it's honest then, truthful then, issue an NOI, and then if it's appeal, and these have been challenges. You mentioned fair evasion. I worked on that a bit previously too. Those cases, when you find out that they are not the real name, so then who will OIH send the notice to? So the challenges do persist. So that's what.
Has it gotten any better with the vending zone manager in place to address any of those challenges? Are we
We
getting
are-
upstream of it a bit?
We have been working with the vending zone manager. We are working through with that. So I do not have any data to present on that right now.
One of the things we heard in testimony yesterday was that the same performers often frequent the same areas and are well-known by the community, which to me seems like an opportunity to think through creative solutions. So I want to put that out there in the same way that ultimately, once the vending zones are fully implemented, that vending zone manager is going to know who's there every day and have those relationships and try to address it. So just thinking bigger, we may want to identify another management structure in certain commercial areas where we see a lot of busking. I know you're going to have a hearing chairman on my bill in the fall. Perhaps that might be the right place for something like that. Now, one thing you also mentioned was that the performers may reduce volume or leave when they see DLCP staff, particularly those with sound meters. Well, I guess you don't have sound meters. So we've previously discussed the potential benefit of DLCP being able to receive photo or video evidence as part of complaints. Would this type of information support complaint investigation?
No, and I thank you. We have had that discussion previously. The photo or video will possibly help to identify the person, but they don't measure the sounds, the decibel. So in terms of substantiating the noise violation, no, the photo or video would not be helpful.
What do you think of the idea of requiring that amplifiers be permitted and only allowed if someone has a permit for an amp?
It's an idea. I would have to give that some thought and also research some of the other law. I know you mentioned Houston does that, see what that structure or how they have done that. I would want to explore that further.
Ms. O'Meara, for First Amendment activities, which MPD deals with all the time, what triggers the requirement for a permit?
So in the district law, under the First Amendment Assemblies Act, there is a requirement that groups have a permit. However, it also says they're not criminally liable if they don't have a permit. So really, there isn't. It is voluntary compliance. And as you know, MPD works diligently with anybody who wants to come to the city and exercise their First Amendment rights. We look at, in working with them, how we can make sure they can, get their message across in the way that they want to, while maintaining safety and, mitigating some of the inconveniences. In particular, that comes in the area of when they are marching and it's in the roadway. So if it's a small one and we can keep it on the sidewalk, we'll do that. We will have other protests where we will walk, lead them and behind them and close down the road as we go. And certainly, we hear from district residents about that. I know you do as well. We have sort of some firmer lines around blocking 395, 695 for public safety reasons. So it's a wide variety of tactics and strategies to both work with whoever wants to demonstrate here in the city and try to protect the interests of the residents as well.
Do those often have amplified sound?
I don't know how many do or don't. Certainly we do have many that have amplified sound.
Any
But certainly
lessons?
the district, I'm sorry, what?
Go ahead.
The district has certainly seen them in the past. The number of demonstrations that we have in the city have just increased exponentially over the past 4 years. I think we're working with 4 per day. And so the range of activity just continues to grow.
For DOB, Mr. Parsons, you've emphasized a number of times the importance of something being at a fixed location. It occurs to me that for the most egregious cases that have been a part of the discussion here, they really are a fixed location, even though it's a person standing on the street. Perhaps part of this conversation is about, you know, areas that meet a certain criteria. A commercial corridor with residential above it, or, you know, we, even with the knowledge that we have of where busking happens right now, creating zones like we have with vending that have extra layers of enforcement. But I mean, what's your definition of a fixed location for DOB's enforcement purposes?
Thank you, Councilmember, and that's a good thought. One of the key components of a fixed location for us, however, is the fact that it is private property with a private property owner, someone who is ultimately responsible for the thing that can be identified through public records. So that's something that, you know, we lean on in resolving those types of cases that may not apply in public space. I also have the answer to the question you asked earlier, how many devices we have. The answer is 6.
Thank you. 6 devices. Okay. Let's come back to this question around amplified sound coming from vehicles, which hasn't been as much a part of the conversation as the stationary buskers have been. Is amplified sound from vehicles a common call for service for MPD or DOB or DLCP?
I wouldn't say it's a common call, no.
Anyone else?
We do not get noise complaints outside of the trash trucks and the gas-powered leaf blower usage, so no.
Okay. Does DOB ever get noise complaints about vehicles?
I would agree with my colleagues, Councilmember, that it is not common. The only case I can remember ever was from the pre-split era. There was a complainant who would regularly call about a mysterious ice cream truck with a buzzing bell. I mean, it didn't sound like a bell, but yeah, so I'm only recalling one case in however many years. I guess I've been there since 2020.
So it does say, it does make sense that a verbal warning doesn't make sense in the case of a moving vehicle. Would it make sense to just sort of exempt from that, like not having that first verbal warning, but going straight to the second step for enforcement?
If there's going to be enforcement, yes. Yeah. And I can tell you, MPD, when we're doing traffic stops and traffic tickets, 1/3 of our tickets are warnings.
Mm-hmm.
You know, we do work to try to educate the community and educate drivers as part of our general public safety efforts. But it would need to be on the first available at the initial stop.
So if enforcement of public performance that someone's doing is to make money, doesn't that count as regulating business activity? No?
Not according to the court, no.
No. The court. Them again.
Yes, ma'am.
Okay. All right, Ms. O'Mara, while I have you, I wanted to ask you about a couple other things. So last year there was an MPD directive on street vending that was given to officers. It gave the impression that officers are no longer empowered to engage vendors to enforce illegal activity. It said, and I quote, "All criminal penalties for violations of any laws or regulations related to vending from a public space have been eliminated." Now, as you know, the street vending law made no changes to the criminal code prohibiting retail theft, the sale of stolen goods, alcohol, or other controlled substances. I wanted to just ask if it's worthwhile to do some clarification there, because I think there was some misunderstanding among officers on the street about the pursuit of illegal activity.
I think it was clear in terms of the change was specifically to vending laws, but we can certainly have some further discussion around that. It's certainly something that in the districts, our district commanders are very keenly aware.
Yes.
There are limits in terms of what a patrol officer can do. Those other crimes often require more investigation as opposed to vending without a license was something that, somebody working on the street could easily tell you have a license or you don't have a license.
Mhm.
And so we're talking about sort of different approaches. And so our district commanders are working with, some of our other units on different approaches to it. And so it may be something that street officers are not necessarily able to enforce the other laws as easily. But there is still activity going on
Sure.
in terms of addressing it.
And I can imagine it would be difficult to identify whether, for example, consumer goods were obtained legally or illegally in order to be sold on the street. One example that might be a little more straightforward is illegal fireworks.
Yes.
An officer is trained typically to know I mean, these are not bang, snaps, and sparklers. These are the big guys. If somebody is selling those on the street, MPD still has the authority to go and confiscate those goods or make an arrest or
Mhm.
whatever they would do in that case. Yes.
Yes.
Okay. And then one other quick one, and then we'll turn to the Lamp Act. I also wanted to ask about the sale of alcohol out of coolers on the sidewalk, because I've been hearing a lot about this happening on U Street recently. And when I've talked to MPD about it, they've said ABCA has to deal with it because they're not allowed to do anything related to street vending. But it would seem that it's pretty clear alcohol is not allowed to be sold on the street.
I was not aware of that becoming a common issue. I will look into that for you.
Specifically
Yeah.
on U Street.
Yeah.
Thank you
Yes,
so
ma'am.
much. I appreciate all of your testimony on this topic. Anybody who is remaining behind to speak about the Lamp Act, we'll keep going for a few more questions. Thank you.
Thank you.
Chairman, I'm sorry, did you have any more questions? Okay, great. You're not here for the Lamp Act.
Councilmember and Chairman, may I be excused if you're going to move to the Lamp Act?
Yes, you may be excused. Thank you for your testimony.
Thank you.
Thank you.
Do you need a break?
To answer the question, well, we submitted the written testimony.
Yes, but
so-
do you need a break?
Oh, no.
Okay, okay.
it's fine. But thank you.
And do you want to read your testimony? Or do you want to read your colleague's testimony or the Lamp Act or no?
No.
Okay.
We can just go straight to.
All right, then we'll just go to questions. Okay, what is currently required to obtain a property management license?
So the current requirements for a property manager, generally speaking, very much a high level. There's the age requirement. They have to be at least 18 years of age. There's the examination requirement. They must complete and pass the examination. They must also have a high school diploma or equivalent. They cannot have had their application previously denied for a reason others, except for having not passed the examination. Their property management license could not have been suspended at the time of application, whether in the district or in another jurisdiction, or revoked within 3 years, either in the district or in another jurisdiction.
What are the continuing education requirements to maintain a license?
So there are two. There's the 6-hour property management coursework, as well as the 9-hour mandated coursework, both approved by the Real Estate Commission.
Those are annual?
I think it's at the renewal, right?
Say that again?
At renewal.
At
so
renewal.
by-
Oh, at renewal. Okay, every 2 years. Okay. What's the current cost for a property management license?
The license fee is $170. That will include the $60 for the real estate guarantee fund because they're required to pay into that, and the $65 application fee.
Is that going to change under the BEST Act?
No, because the BEST Act applies to basic business licenses. This is an occupational professional license, so those fees will not change.
I know that you would need to develop a licensure exam and other requirements for this new structure, but do you anticipate that the requirements for firms would be different than that for the individual?
I'm sorry, would you mind repeating the question?
Not a problem. So do you anticipate that licensing exam and other requirements would be different for firms than they are for individuals.
No,
In the written testimony we've received, it says that under current law, complaints against property managers can be filed against the Real Estate Commission, who can choose to take action. I know the director of the commission was unable to join us today, but I would like to dive into this complaint process a little more to understand the current protections. Are you able to share how many complaints the commissioner receives a year and what the outcomes of those complaints are?
I do not have that data, but I can follow with the committee on it.
Do you have any idea of how often fines are issued or if licenses are suspended or revoked?
I will have to get that data from the
Okay.
staff.
I was concerned by testimony we heard yesterday about how frequently misconduct may be happening and the seeming lack of repercussions for these individuals. So would like to know.
Yeah, I do
that.
not know the numbers. I can follow up on that, but in terms of what I am familiar with, they have previously done it, at least in 2 cases. But do you have a time frame I can look within the last FY?
Ye-
period?
Yeah, fiscal year is fine. 1 complete year of sorts. It's just
Okay.
so we get a sense of frequency.
Okay.
In addition to those complaints, are there other ways the commission may be notified of misconduct? So, like, for example, via a police report?
I'm not familiar with that and I can discuss with staff. Have they ever seen that and follow up? But I'm not familiar with that and have not been privy to it.
Last year, ANC 8F passed a resolution calling for the district to revoke the business license of Urban Investment Property in response to repeated resident concerns about one of the properties they managed. Was DLCP or the commission notified of this?
I'll actually have to follow with that because the request to revoke their basic business license will be outside the commission's purview. So I will follow up and see if we received that resolution, that request, and the outcome.
Okay. We heard a lot of testimony yesterday about the common interest communities like condo boards. I know these entities were primarily the ones harmed by Ms. Sears' embezzlement, and I'm curious how this legislation might protect rental communities, like the ones who called for the resolution against UIP. Does DLCP often receive complaints related to the management of rental properties?
Some may go to the commission. I have to see exactly how many, but these are, and I watched their testimony as well, the community association. So this bill would apply to licensure of property management businesses, right?
Yeah.
So we do require, we did submit a red line that would suggest that the council consider adding the community association. But the bill that was initially, has been introduced doesn't include them. We do receive that is an area of concern because they also are engaging in the same type of responsibilities as the property managers regarding the community associations, including the fiduciary responsibilities. So as you saw in our red line, we would suggest consideration of adding the community associations.
Great. Under the current system, is there any situation in which a property management license applicant would be denied?
There are under the current structure where a property management license could be denied. There are myriad different ways, obviously if they do not meet the basic requirements, if they, and then that's in terms of like age, minimum, et cetera, if it's been suspended. So there are there are ways in which the commission could deny an application.
We heard a lot of testimony yesterday from stakeholders in the property management field who said this legislation would not prevent misconduct and that fidelity insurance requirements would be a better way to protect property owners. Could you detail some of the enforcement benefits of licensure structure?
Sure. And we thought about, after listening to that testimony, we will want to work with the committee and explore the possibility of adding fidelity insurance, but we do not think that alone will address this issue. I can appreciate what the witnesses, their position that this bill would not eradicate or prevent or deter bad acting, but no law actually will do that. What we're trying and what we think this bill does do, and it's the first step in doing, is providing some oversight that will allow the commission to establish some base mark requirements, open up that ability and opportunity for other courses, avenues of recourse for the commission. Right now, if the property manager is not licensed, so just focusing on the property manager, if the property manager is not licensed, there's no action that the real estate commission can take. They will have to be referred to DLCP, possibly on a basic business license, the CPPA violation, or if their business wasn't registered. With the property management companies, definitely, but not within the real estate commission's purview. So requiring them to be licensed would bring them within that framework. And we already discussed some of the education requirements and such, but also other, if necessary, different enforcement action that can't be taken outside of being referred to DLCP because they could, basic business license, CPA, and a registration, or having a complaint being referred to OAG, or in the last course action, if one takes a private course of action against the property manager.
Mhm.
So we recognize that will the law or any law deter or prevent? No, but this does provide a basis of further protecting residents.
Thank you. And thanks for the red lines of the legislation that you provided along with your
Yes, you're
testimony.
welcome.
As you mentioned, common interest groups can also be open to cases of fraud and misconduct. Are there any additional considerations for how this may impact these groups since they aren't traditional businesses?
The common interest group. And that's why we would recommend adding them to that definition.
Great. Anything else you want to add?
Not at this time, but I would like to reiterate, a willingness to continue to work with the council on amplified noise, but also this bill as well as with the stakeholders and interest groups. I mean, there's definitely some areas, the bill is not perfect, and we presented a red line, they have some suggestions, and I think there is definitely some room to further tweak the bill for the purposes that we're seeking.
Great. Thank you so much. And this will conclude today's hearing. Thank you, everyone, for your participation. For those who have not yet submitted written testimony, please do so by submitting it on the council's hearing management system. The record for this hearing will close at 5:30 p.m. on July 17th, 2024. The time is now 11:38 a.m. and the hearing is adjourned.